Yes, Mr. Eardley, we're going to look at the second case.
Yeah. Just before I get to the second case, before I forget, can I give you the list of those other exemptions that have a likely prejudice formulation in them?
Did you have that in writing?
I could certainly ask my solicitors to forward it.
I think unless my lord wants it now,
I think it's better to have it in writing. And just have we got all the statutory material?
Yes,
for
it's all within Schedule 2, which is reproduced completely in the file, so you can look at them all. I'll get those forwarded. Yes, the second case I was going to mention on this question of whether the duty to have regard is a fairly toothless light public law duty is the Good Law Project case, which the judge cited in support of that proposition. We say it doesn't support that proposition. It's at tab 14 in the first bundle of authorities. This was a case in which the claimant organisation had identified a number of policies about the use and retention of social media communications within government, and was arguing that ministers had used social media in breach of those policies. And the problem for the claimant in that case, as the court found, was that they couldn't point to any statutory provisions at all that said that anyone should have regard to those policies. They were simply policies in the background, and you get that at paragraph 61 of the judgment on page 482. Parliament often sets out the extent to which policies and guidance must be taken into account by a public authority. To include there is a duty to comply with the 8 policies would be incongruous in the absence of any such provisions in the PRA or other legislation. And then notes those such provisions don't impose any duty to comply with the guidance once produced. So it's simply not a case about the strength of a duty to have regard. There's simply nothing comparable to look at in that case at all. The reason I was dealing with the duty to have regard is part of my submission that the judge underestimated these ancillary features of the exemption. Not only you should have a policy, but you should have regard to it, etc. And another way in which we say he underestimated that is he underplayed the duty to publish policy. In paragraph 64, little 5 of the judgment, he suggested that that was a really very undemanding requirement that could be satisfied simply by putting a notice in the London Gazette or similar. Again, we say that what's there on the face of the regulation is a much stronger duty than that. It's a well-known principle of public law that if there's going to be a policy that has to be published in a way that gets to the people who will be affected by the policy. You can derive that from the lumber case, for example. And so, plainly, a policy of this sort, which is potentially applicable to many, many data subjects here and abroad, is going to have to be published in a sufficiently widespread way that we suggest, obviously, online. Some point is made that there had been at one stage in the draft amending regulation a reference to it being published on .gov.uk, which then disappeared from the draft. Nothing sinister in that, we say. That's just good draft. It will stand at the test of time if in the future the government decides to put all its policies and information on some different website that doesn't end with .gov.uk. But the duty to publish is a strong one. It has to be an effective publication that comes to the attention of people who may be affected by the policy.
Sorry, what do you say Lumba is authority for? That if the government has a policy, it must publish it.
If there's a duty to publish, it's got to be effective publication.
I see.
Got to reach the people the policy is directed to.
But why isn't publication in the London Gazette sufficient for that purpose?
Because data subjects whose data is being processed by the Home Office will not be read as the London Gazette, but they'll be interacting constantly online. So it's not like the announcement of an insolvency or something where everybody knows there's one place to look and that's where you go to get your information. It's a different audience, and so it's a different method of publication that's required. I can move more swiftly through the last 3 points I make in my skeleton on ground 2. First of all, the point that I've already laboured somewhat, that when you are considering whether the requirement to have a policy document and ancillary requirements amount to sufficient safeguards, you have to look at that along with all the other restrictions, conditions in the regulation. That includes the self-limiting likely to prejudice test, the fact that we've got a fairly short list of provisions that can be derogated from, and the fact that we're dealing with one single controller. The 6th point I make is that because what we're ultimately concerned with here is proportionality, you have to look at the nature of the rights and obligations that could be restricted or derogated from here. I've taken you through those rights and I've shown that they are fairly limited and qualified rights in some respects. We are a world away from the sort of processing that was being legitimised by the measures that were under challenge in La Quadrature, in that line of e-privacy cases, e-privacy directive cases, for example, which legitimised processing that wasn't lawful at all, and legitimised doing so on a huge scale. It's for that reason, in that case, and other cases, the CJEU has said that to ensure proportionality and lawfulness in that sort of context, then yes, you need such things as prior authorisation by an independent body. Nothing of the sort carries across here, where by definition we're dealing with rights that are asserted by an individual. Please may I have my data, please stop processing my data, which then has to be assessed on a case-by-case basis before the exemption can be applied. And the last point I make is that the consideration of some need for flexible, operational flexibility is respectable. It's the point made in La Ligue, the Ligue des Droits Humains case. So long as the essentials that secure that the rule of law requirements proportionality on the face of the regulation is acceptable, particularly against a background of changing and wide-ranging facts, but to leave the detail to go into policy which decision makers must have regard to. Moving then briefly on to ground 3, this arises from paragraphs 69 to 74 of the judgment, and it concerns Article 23 to G. It's worth just looking at Article 23 to G in the authorities, tab 32, page 1583. Because it sits rather uncomfortably on the list of specific provisions, it's clear enough when the list is said it must contain a specific provision as to the purpose of the processing or the categories or specification for the controller, for example, but quite what is a specific provision as to the risks to the rights and freedoms of data subjects. You can't analyse it grammatically in quite the same way as the other requirements. The judge appeared sympathetic to the point I made about that. We say you can look at it in two ways, and whichever way you look at it, it makes this amended exemption lawful. The first way is this: if you accept that what you get from the Court of Appeal's decision in JR1 is that you have to look at all the requirements together that are set out on the face of a regulation and ask if anything more is needed in order to address what's left on the list of things that aren't expressly addressed in the regulation, then you can draw the conclusion that there is so much here on the face of this regulation, and in particular the likely to prejudice test, that it's plain and obvious that the rights and risks of data subjects are properly protected by the other provisions working together, and that nothing more needs to be said there. So if you accept, and we don't dispute, that the concern here is that we're dealing with data subjects who may be vulnerable individuals with a pressing need for timely and full information that will allow them to challenge immigration decisions, well, we say all those protections are properly built into the test that's already set out on the face of the regulation. And we say just reciting it again on the face of the regulation would have no meaningful effect. It would be virtue signalling in a way. The other way in which requirement G might be interpreted stems from the approach that is apparently endorsed by the European Data Protection Board in their guidelines. They're at Article 37, I beg your pardon, tab 37 in the second authorities bundle. Starting at paragraph 58 on page 1693. This is a document which Lord Justice Warby had regard to in JR1 as having some relevance, and we would suggest it's relevant here too. What is said, paragraph 58, is that GDPR requires that the legislative measure include the risks to data subject rights and freedoms entailed by the restrictions. Unclear what include means there. But then it says the goal of this assessment of the risks is twofold. On the one hand, it provides an overview of the potential impact of restrictions on data subjects. On the other hand, it provides elements for the necessity and proportionality test of the restrictions. In this regard, and if applicable, a data protection impact assessment should be considered. And then it says legislation should assess the risk to the rights and freedoms from the perspective of data subjects, not always mandatory to perform a DPIA, but concrete risks to data subjects such as erroneous profiling leading to discrimination, reduced human dignity, freedom of speech, right to privacy and data protection, bigger impact on vulnerable groups, to mention a few, may be stated in the legislative measure if applicable. When such an assessment is provided, the board considers it necessary to include it in the recitals or explanatory memorandum of the legislation or the impact assessment. So what they seem to be saying is that in the course of producing derogating measure, a process has to be gone through where the risks to the rights and freedoms of data subjects are properly taken into account when settling the terms of the exempting measure, and that has to be recorded in some way. They suggest an explanatory memorandum or recitals. And if that approach is right, then again we say this measure passes that test. There is an explanatory memorandum which demonstrates that consideration of these matters has been undertaken. You'll find that in the supplementary bundle at tab 15, page 255. And Article 23.2G is addressed in paragraph 7.10. And what it says there essentially is that it has been considered whether anything more needs to be said specifically about rights and freedom of data subjects. Answer no, because the likely prejudice test already gives sufficient protections. That is evidence of the sort envisaged by the EDPB. We would say that proper thought has been given to these matters in the process of determining what terms should appear on the face of the legislation. Another place one can look for evidence of that having been undertaken during the course of the preparation of the amended regulation is the rationale and reasoning note.
Just before we leave paragraph 710,
Yes.
that seems to present the question as a binary question, either prejudice or no prejudice, rather than a balance between some prejudice on the one hand and severe interference with an individual's rights on the other, with, let us say, the prejudice outweighing the rights, which is, as I understand it, what a balancing test is.
Yes. I understand why Your Lordship says that's what it appears like there. I've explained that the likely prejudice test does involve the balancing exercise.
Yes, well, that's what you've said, but this paragraph doesn't seem to reflect that.
It doesn't. I'm just looking to see if that point has already been covered earlier on, which might explain why it's somewhat glossed over there. No, it doesn't appear to go into any greater detail, so it's a correct observation. I was taking you to the rationale and reasoning note, which is at page 100 in the supplementary bundle. This version is the latest of the versions in the bundle, and it dates from March 2022, which is of course after the regulations came into force. Mr. Prince gives evidence about that, and it wasn't challenged. He says at paragraph 15 of his statement that the details set out here reflected the thinking at the time of the enactment. So this is a proper record on his evidence of what was considered at the time of this legislation.
Sorry, where is that evidence? Which page?
Beg your pardon, the note is supplementary bundle, tab 2, page 15.
Thank you.
And little 2G is addressed at paragraph 9 on page 103. I'll invite your Lordship just to read that paragraph and over on to 104. It recites in some more detail the considerations that have been taken into account when deciding whether the regulation as drafted properly does protect the rights and freedoms of data subjects.
How does this sit with the requirement that it has to be in the regulations?
Well, it doesn't, but at the moment I'm addressing the EDPB approach,
Yes.
which appears, in respect of this particular provision, to say it's more about process and evidence of the process rather than what's actually in the regulation itself. So your lordship's quite right. It's not on the face of the regulation. It's not part of the regulation. But on the EDPB approach to this rather odd provision, it may be some evidence that the right things have been thought about at the right time. That's all I could usefully say on ground 3. Can I just briefly address you on the points raised in the respondent's notice? This is, in effect, a cross-appeal by the claimants below, because each of the 3 points that they put forward as additional reasons to uphold the judge's decision that the regulations are unlawful were points expressly considered by the judge and rejected by him. It's only because of the form of the order that the claimants managed to get it in as a respondent's notice and didn't have to seek permission of this court to raise these points. I may reply at greater length once Mr. Jaffe has developed his case on the points, but very briefly, that we say that the judge rejected each of these points properly for the reasons he gave. The first criticism raised by the respondents is that the judge should have found that effective immigration control is an insufficiently precise term for a regulation such as this. The judge dealt with that very clearly at paragraphs 48 to 50 of judgment. Effectively accepting my submissions there. I don't need to spend any more time on that point. The next respondent's notice point is a suggestion that we've failed to restrict this new exemption to one controller at the Home Office, and that it's open to be interpreted as being used by other third-party, perhaps private sector controllers. Again, the judge deals with that succinctly at paragraphs 58 to 60 of the judgment. Again, I may ask to reply for a little bit greater length tomorrow, depending on how Mr. Jaffe develops that, but we say that's a sufficient reason for rejecting that point that's given by the judge there. And then the last point the respondents seek to raise by their notice concerns alleged non-compliance with little 2f. That's specific provisions as to storage periods and applicable safeguards. Again, we say how the judge deals with that, paragraph 66 through to 68 of the judgment, are adequate and correct. But this regulation doesn't need to say anything about storage periods because it doesn't purport to extend the periods that would normally apply in any event under the general requirements for fair, lawful, etc. processing under Article 5.1. So as I say, I may have a little more to say on those tomorrow, but I don't need to trouble you further at the moment. The last matter I said I would address you on is the timetable for further amendment, if that's what has to happen as a result of this appeal. My Lord Lord Justice Singh asked where the evidence is about that. The evidence is contained in the witness statement of Mr. Prince that was put in support of the application.
Well, that's the evidence that was used in support of the application for the stay.
Yes.
I mean, are we to assume that the relative timescales are still accurate, but push the dates back by whatever the time lapse is between then and now? Is that how it works?
Not quite. What Mr. Prince sets out is how how the government could just about meet the timetable of 3 months that the judge had put in place. Although he says that it would be suboptimal in his words.
Yeah.
What I'm instructed now is that what is required to do it safely would be a period of 6 months, but realistically 4 to 5 months. I have information about how that's broken down into the various stages as we've gone through.
Well, I think if the relative timescales are going to change, we will have to have some evidence. And bear in mind that you had 3 months first time round, you had another 3 months second time round, and you've had a stay.
Yes. Hands have not been idle, as you can see even from Mr. Prince's witness statement back in April. Policy decisions have been taken about how to deal with this problem. Drafting has begun. But it obviously can't be advanced definitively yet until we know what your lordships say about any deficiencies. What I can offer, and this is already in hand, is a witness statement by tomorrow morning that will set out those revised timeframes that I mentioned.
Well, it won't surprise you to learn that we are not going to give extempore judgments in this case. So I think we'll just get the witness statement in as soon as you can. And of course, if the other parties want to put in evidence in answer, they must be entitled.
Of course. But I'm grateful for that indication. I will get it to the court as speedily as possible. Very well be tomorrow morning, because all the information is there. It just needs to be put in witness statement form. But I won't try and take you through it now on instructions. It's best to see.
It's unfortunate it wasn't produced before.
I note that. Is there anything else I can assist with, my lord?
Thank you very much. Yes, Mr. Jaffe.
My lords, my lady, this is the third and hopefully final hearing in this court about the immigration exemption. What I propose to do is to summarise the respondent's response to the submissions the court's heard this morning, and then deal in slightly more detail with a few points. The first point I'll deal with in slightly more detail is what the revised immigration exemption actually does, especially when it's read alongside the policy document. Secondly, a few of the facts found by the judge and also found in the first judicial review. Thirdly, in slightly more detail, what this court decided in the first judicial review. And then I'll turn fourthly to the grounds of appeal, the respondent's notice points. And there is also a ground of challenge about the judge's decision on timetable, and it's a procedural fairness challenge. Now, that wasn't developed in any detail by my learned friend in his oral submissions, but I assume it is being pursued, and so I'll briefly respond to that as well, if I may. Before I cover those points, I think it's worth summarising what we say the basic answers to this appeal are. The judge found that the Secretaries of State had not done what this court indicated needed to be done last time around. We say that's unlikely to have come as any huge shock to the Secretaries of State, because the points which the judge found in favour of the claimants were those that had been made by both the respondents in this appeal and the Information Commissioner in the statutory consultation which took place. And what the judge actually did we say was modest, and it reflected the judgment in the first judicial review of this court. The judge did not in any way prevent there from being an immigration exemption, nor did he seek to attack its existing scope and content. What the judge required to happen was that there be express legislative consideration of a group of safeguards in the categories in Article 23(2). And those are safeguards which, if they're appropriate, can be introduced using existing powers in Section 16 of the Data Protection Act to modify the existing exemptions. That was how the revisions which are made, which are now under challenge. And we say that task was made considerably easier by the guidance which had already been given by this court, and also made easier by the statutory checklist in Article 23(2, which the judge sought to apply. And at the heart of this appeal is really a question about what Article 23(2 actually does. And it's this court said in the first judicial review, it's a new provision which hadn't appeared in other legislation previously, but it looks like, and indeed it does, codify much of the existing Court of Justice case law. And what it seeks to do is to ensure that where there is a derogation from fundamental rights, that derogation has to be in a legislative measure, and it has to be accompanied by specific provision, where appropriate, about a series of categories of safeguards. And within that, the crucial feature is that the safeguards are to be contained within a legislative measure itself. So the controlling and safeguarding measures are in the legislative provision. So why is that? Well, the answer is that the fundamental rights which are concerned, and here those are the rights in the UK GDPR, are conferred by legislation. They're conferred in, at least at the moment, by retained EU law. What is happening under the immigration exemption is that some of those rights are being derogated from. They're being removed. And where removal takes place of rights which have been granted by legislation, equally there needs to be a legislative measure which removes them, and also the safeguards and procedures which protect against the misuse of that derogation are also to be in a legislative measure. That is different from some of the arrangements which are in place when a right is said to be being exercised, but the claim fails on its facts. So, for example, there are conditions in Article 9 and also in domestic legislation about sensitive processing and when sensitive processing may take place. One of the provisions of domestic law, which you were shown by my learned friend, is a provision requiring a policy. And that is a means by which compliance with Article 9 is assured as a result of provisions of domestic law. That's very different from a derogation. And the derogation is where there is legislation in place which removes the right rather than ensures its compliance. And that's the distinction, and that is why Article 23(2 and the case law which precedes it and follows it has always indicated a much stricter approach to derogations and legislative measures. Indeed, that was a point that was made by this court in the first judicial review.
Mr. Jeffrey, can I just take you back to if I've understood the submission correctly, that you say that this has to be in the legislation itself because the rights are conferred by legislation. But does that go too far as a principle? Because there are lots of fundamental rights which are conferred by legislation. In one sense, the Human Rights Act confers fundamental rights by legislation. But as I understand it, it's well established that derogations from those rights need not necessarily be on the face of legislation. They can be contained, for example, in a policy document.
And one thing that has been said by the Court of Justice, and they've said it on more than one occasion, is that the approach which they adopt to derogations and legislative measures is in a number of respects stricter than has been traditionally applied in the Strasbourg case law, which, as my lord put to my learned friend, goes back to cases such as Silver in the UK, I think in the 1970s, about the use of policies. And that is why the Secretary of State concedes before this court, and indeed conceded below, that the immigration exemption policy document is not a legislative measure. And that concession has been maintained in oral submissions today, rightly, we say. I'm happy to take the court through it. My learned friend didn't, but there are a series of decisions pointing out that the approach of the Court of Justice has always been different to legislative measures, and there is quite detailed analysis in at least one Advocate General's opinion as to why that is. One Advocate General in the Telly 2 case went through the history of the concept of a legislative measure, the various different language versions, and the application in a number of cases, and concluded that it meant something rather stricter than had always been understood in the Strasbourg case law.
You may be right, but is it also, at least in the alternative, a part of your submissions, that whatever the general position may be, here we have specific legislation, and that the terms of Article 23, paragraph 3, require whatever it is done to be in the regulation?
In regulations, indeed.
I mean,
that's the short answer. I don't want to. The reason I make this submission is to explain how we got here.
right.
And it may be the court doesn't need to accept the full breadth of my submissions about how we got here, because that's what the legislation says. But what I do suggest is that underlying why the UK GDPR now talks about regulations is because of the original text of the GDPR, legislative measures, a phrase which still appears in the recitals, hasn't been removed. And that appears, that concept of legislative measures, because of a long history of Court of Justice case law about exactly that concept and what it means for derogations. So that's how we ended up here. But I entirely accept my law's point that I don't need to put it any higher than it says regulations. And the critical safeguards here, the safeguards against abuse, are not in regulations. They're in a policy document, which it is conceded does not amount to a legislative measure and certainly can't amount to regulations. It's provided for by regulations, but it's not regulations. The three primary grounds of appeal, just to take what we say about them briefly. The first thing the judge found that is challenged in ground 1 is the judge said it was necessary to include a requirement of necessity and proportionality in the legislative measure, so in the regulations. And that is a minimum baseline. Now, that is an approach which has routinely been adopted in other derogating measures in the United Kingdom. It's also an approach which, at least in some cases, has been required not just by the Luxembourg case law, but also by the Strasbourg case law. And I'll show the court one example of that. But here, all the judge was doing is saying that one of the basic requirements is an individual assessment of necessity and proportionality. That's one of the basic safeguards.
In the sense of what?
One of the basic safeguards is
yeah.
an individual assessment of necessity and proportionality. And all the judge is saying, well, that needs to be on the face of the legislative measure. It wasn't, in fact, a particularly onerous requirement. It's quite a modest amendment, which, although there's a package of things, certainly oughtn't take several months to fix.
I think the main point that's made against you is that it is. It may not be express, but on its true construction, it is an implied requirement of the legislation.
Yes. And the answer to that is that there are certain critical safeguards that do need to be in the legislative measure itself. That is, or the regulations. That is the text of the UK GDPR, and similar arguments have been made and have been accepted in the past. That, in other words, it is necessary to put on the face of the legislative scheme a requirement of necessity and proportionality. And my learned friend's reliance on the case of Lin in particular is, we say, inapt, because that is a case where the in accordance with the law argument was not rung. All the court was doing in that case was applying the requirements of proportionality to the facts as found by the judge. The judge was not asked to consider, and did not consider, whether the scheme that was in place there was in accordance with the law. That's the difference with Lewison. That's the first ground. The second ground relates to the policy document. The text, and we'll look at the text in a moment, of the revised immigration exemption accepts that there need to be measures that deal with the risk of abuse. The word abuse is there in the revised exemption. And the reason for that is because of Article 23(2)(d), which is the provision about safeguards dealing with the risk of abuse. But the difficulty the Secretary of State has is that the decision was taken to put the substance of the safeguards in a policy document, which the Secretary of State concedes is not regulations. The consequence of that is that there is no legislative approval of the content of the safeguards against abuse. And it goes further than that. The Secretary of State does not invite you to rely on, or even to look at, the contents of the policy document. Court's not even been shown it in the context of oral submissions. But despite that, it said that without any process of legislative review or approval of the policy document, that is an adequate way of addressing and providing safeguards against abuse. Now, for the historical reasons about how we got here, I say that's clearly wrong, and I also say it's wrong on the text of Article 23 of the UK GDPR as it now is. Because the purpose of that scheme is to require the safeguards to be in legislation, and the type of legislation is a regulation. And when we look at the policy document, I'll say that, in fact, it doesn't contain any real safeguard against abuse. There's a very elaborate procedure for its production, but the cupboard is actually bare. That's what we say on ground 2. Ground 3, if it's convenient, Mr. Knight will take the lead on the arguments on ground 3, as he did below. He dealt with the same point below. But the difficulty with the Secretary of State's position on ground 3 is that at the time these amending regulations were made, the Secretary of State's position was that the duty in 23(2)(g), G is what ground 3 is about, was not really even engaged. The Secretary of State did not accept there was anything that needed to be done under G. Our response to that is that G was clearly engaged. The judge explained perfectly properly in broad terms what needed to be done and why it, in fact, also wasn't particularly onerous, but it was also important as a matter of principle to be done. And then finally, I'll deal with the procedural fairness challenge. It's probably not of great practical importance to either party, because whether or not the judge was right to set the timetable he did, and we say the judge was quite right to set the timetable he did, it's water under the bridge. Because if the Secretary of State's appeal succeeds, there will be no timetable, so it doesn't really matter. And if the appeal fails, there will have to be a new timetable, which is set by this court. So in practical terms, whatever its importance, a matter of principle, if the judge did make a mistake, it's probably not going to make much difference to the actual parties to this appeal. So if I can turn, with those introductions done, to deal first of all with what we say the immigration exemption does. With apologies for asking you to go back to it, I can do it quite briefly. And if we perhaps stay with the tracked changes version that has been used this morning, that's in the supplemental bundle at page 84. In subparagraph 1, we have the scope of the derogation. And the derogation is quite broadly drafted. It covers personal data processed by the Secretary of State for the purpose of the maintenance of effective immigration control, or, and then the second gateway, which is potentially wider, the investigation or detection of activities that would undermine the maintenance of effective immigration control. What the derogation does not seek to do is it doesn't seek to identify any particular use cases or circumstances in which it will be applied. It's quite general wording. The rights that can be removed have already been identified by my learned friend Mr. Eardley, and they're on page 85, and they are listed. He went through some of them, but just to mention what they are, and we probably don't need to get out the UK GDPR for this purpose. The common feature of all of these rights that are listed in subparagraph 2 is that they are rights which are important because in practice they are a precondition to first of all being aware that data is being used, and secondly being able to challenge any use or misuse of data. Just as a matter of practical reality, it's impossible to challenge the use of data if a person doesn't know that it's being held, how long it's being held for, and how it's being processed. All of these rights also have built-in exemptions of their own, and some of those were shown to you earlier in submissions today. So just taking them in turn, Articles 13 and 14 are the obligation to tell a data subject that you've started processing their data and why you're processing it. Those rights are already qualified rights with exemptions. So they are already provisions without the need for a derogation for where the public interest requires not complying with them in full. So one of the spectres in this case is the idea that if somebody is an overstayer and the Home Office have found out where they're living, then they can potentially make a request and the Home Office have to tell them before they send a van to detain them that that's what they're going to do. Before we had the immigration exemption, that doesn't seem to have been a problem in practice, and that is because of the built-in exemptions to data protection rights which have always existed. Article 15 is the right to make a subject access request. That's always also been a right which has limitations built within it. Personal data has to be disclosed, but what a public authority doesn't have to disclose is, for example, what they intend to do with that personal data in the future. And there's a series of case law about that and the scope of that right, which I won't take the court through. But again, these are rights which have built-in limits of their own. Then Article 17 is the right to erasure. Again, it's a limited right where there are overriding legitimate reasons in the public interest. It doesn't have to be complied with. But the immigration exemption goes further than that. Even when there are not those overriding legitimate reasons in the public interest, the right itself can be disapplied, even though the right contains its own limits. Article 18 is quite similar, about restrictions on processing rather than full erasure of the data. And then Article 21, which is the right to object to processing, again contains the same mechanism to limit the right without a derogation on compelling legitimate grounds. The effect of the immigration exemption is to remove even that strict test. In addition, as my Lord Justice Lewison pointed out to my learned friend earlier, the immigration exemption can also be used so as to not disclose that data has been transferred abroad. And the effect of transferring data abroad is that in practice there is no longer control over it, including legal control by the courts. And if a person is not told, as a result of the immigration exemption, that the data has been transferred, in practice they have no means of objecting to that transfer. That doesn't take a huge amount of imagination to think about how that might well be significant in the immigration context. For example, if information is transferred to a country where a third country national may be, visit, or end up. So we say that the immigration exemption is actually quite a broad provision. And that's relevant when considering the question of safeguards. It actually sweeps quite widely and potentially has the effect of preventing public knowledge of quite wide-ranging profiling, assessment and data transfer activities.
Can I just see where we're going with this one? You've quite rightly said that a lot of these rights are qualified rights in the sense that matters of public interest of one kind and another can prevent their effective exercise. And therefore, even without a derogation, there will be many cases in which the data controller need not disclose the information or personal data or whatever. Article 23 says that you can have a derogation where it is necessary. And is the point that you're getting to that it's got to be necessary because the existing rights to withhold information are not strong enough? So there has to be something that is even greater than could be achieved through the existing qualified rights in order to justify a derogation at all.
Yes.
But you accept, I think, that a derogation, there's nothing wrong with an immigration exemption.
Not as a matter of principle, no. Properly safeguarded.
But you say when we're looking at necessary in Article 23, that word has to be interpreted in the context in which the rights sought to be overridden are themselves qualified rights.
We do. And so what is intended by this derogation is to go further, necessarily that must be the case, to go further than the qualifications which already exist. Now, the qualifications which already exist are not sufficient or adequate for the Secretary of State's purposes, and therefore it's necessary to derogate as well. And the type of, I'll come to this in a moment, but the type of use cases that we suspect are really most important for this derogation are transfers abroad and large-scale processing and profiling exercises, some of which were mentioned in submissions by my learned friend, who gave examples of profiling activities. Because those are the ones which actually may require a derogation if they're to be carried And the reason I raise this is because one of the submissions which the court heard earlier this afternoon is that it was suggested that we were a very long way away from cases such as La Quadrature du Net. And cases such as La Quadrature du Net are exactly about that. They're about taking a large volume of data, including the data of innocent travellers and UK citizens, and processing and profiling it algorithmically in order to identify people or things of interest.
Mr. Jeffrey,
We say that's exactly what's happening. I'm sorry.
No, I'm sorry.
That's what's happening.
I haven't got a full note of what you said. It's my fault. You said that in practice it's probably required for transfer abroad and large-scale profiling and
large-scale processing and profiling, type activities. I should probably make that point good with a reference, and the best reference in the evidence is in Ms. Samidi's first witness statement, which is in the core bundle, tab 19, at page 45.
Do you mean the supplementary?
Yes, I do. I apologise. Yes, supplementary.
I don't know about my colleagues, but I don't have tabs in either the core or the supplementary.
I do, but it's a supplemental bundle. I've given the wrong tab number as well, so good job you don't have them. But it's page 45 of the supplemental. And the court should have paragraph 62 in the bottom half of the page of Ms. Samidi's statement. And at letters B and C, there is an explanation of the large-scale processing activities which the Home Office accepts that it carries out.
Yeah.
And she also accepts that that involves, and this is the third line of B, the processing of data from both legitimate and illegitimate travellers. And the effect of the immigration exemption is that it would not be necessary to disclose, for example, when new or different types of processing start, or that they're carried out at all. And so we say that on its facts, this is a case which is actually very similar to cases such as La Quadrature du Net. The purpose of the processing in La Quadrature was national security, and here it's immigration control, but the nature of the processing and the interference, we say, is very similar.
so the fact that it refers to both legitimate and illegitimate travellers, does that mean that sometimes it might be, for example, one of us who is travelling, but they need to be able to obtain that data, they would say, because they're investigating whether somebody else has been travelling unlawfully. Have I got the picture right?
Yes, and my lord, in another context, sits as the president of the Investigatory Powers Tribunal, and it would just be used by the shorthand name of bulk in investigatory powers. That what you're doing is you're obtaining everybody's data in order to search for things and people of interest. So if you collect everybody's travel data from their passports and data from their entries and exits to the United Kingdom, and you analyse it algorithmically for suspicious patterns of behaviour to identify who you might want to target or to challenge or to question on arrival or departure, that is the type of processing that you wouldn't need to disclose as a result of the immigration exemption, we say. And that is a classic bulk activity which involves not just using the data of people who are under suspicion, but using everyone's data. And that makes it a particularly intrusive derogation.
Is it a power of bulk collection, retention, or only processing?
It's certainly a power of bulk processing, and it may also be used to justify the retention of data as well. So it can be analysed later. And the court also heard earlier citation of Bridges, and one of the points that was made by the Court of Appeal in Bridges is that the effect of the automated facial recognition that was used there was to have at least a potential effect on large numbers of people of no legitimate police interest, because everybody that walked past the cameras was scanned, and therefore everybody was at risk of a false match. And that was one of the factors which the court took into account about the intrusiveness. As against that in Bridges, this court said, well, it's an overt capability. The vans are visible. There's a big sign outside the van saying if you walk past this van, your photo will be taken and we will match it against our database. This is, and the purpose of the derogation, is to make the capability a covert capability. That's the point of the derogation. Otherwise, you would have to disclose the fact of its existence so that people could challenge it. And that's what makes this case one where the interference is potentially much more serious than in Bridges. I think I've covered, in answer to the court's questions, the points that I was intending to make about the factual context already. So I'll go straight on, if I may, to what the Court of Appeal decided in the first judicial review. That's in the authorities bundle at tab 12, first authorities bundle at tab 12, page 424. And if I could pick up the judgment at paragraph 29 on page 436 of the bundle numbering. Lord Justice Warby very conveniently provides, in essence, a ratio in paragraph 29 that the appeal can and should be decided on the following short and straightforward basis. There presently exists no legislative measure that contains specific provisions in accordance with the mandatory requirements of Article 23(2). Therefore, it's an unauthorised derogation, therefore it's unlawful. That's then fleshed out over the page, in particular at paragraph 33, where it's explained that it's a condition precedent for the validity of a legislative measure that Article 23(2) is complied with. Then, over the following pages, there's an analysis of the Court of Justice's case law, starting at paragraph 36. And then at paragraph 37, there is an acceptance of the submission which I made that the language of the regulation reflects the principles to be found in the Court of Justice's jurisprudence. And then an alternative submission made by the counsel for the Secretary of State is rejected. Then the court gives a number of examples of that jurisprudence. And in particular, if I could draw the court's attention to paragraph 41, where the court deals with opinion 115. That's a Court of Justice case about sharing passenger name record data obtained by airlines with a foreign government, in that case the Canadian government. And the court quotes the critical part of the Court of Justice's judgment at the bottom of that page at letter G, and it quotes paragraph 139 in italics. The legal basis which permits the interference with those rights must itself define the scope of the limitation on the exercise of the right concerned. So the derogation must itself contain the limits on the scope of the derogation, which of course includes the safeguards. And that's dealt with at paragraph 141, right at the bottom of the page, and over the page, page 441 of the bundle at the top. And there must be minimum safeguards which protect against the risk of abuse. And that phrase, protecting personal data against the risk of abuse, is reflected almost exactly in the language of Article 23(2). It's that risk of abuse that's in subparagraph D. Then the Court of Appeal in the first judicial review then goes on to analyse some of the other cases, and then in particular at paragraph 45 analyses the La Quadrature case. And that is relevant for the reason given by the Court of Appeal at paragraph 46, which is that La Quadrature applied the same set of principles about legislative measures to the provisions of the GDPR. Because unlike all of the previous cases, which had mostly been about the e-privacy directive, La Quadrature was substantially about the GDPR. And so the copying across of the same requirements was a matter that we say the Court of Appeal correctly identified as being significant. Then paragraph 48 picking it up at the end of paragraph 48 at letter G, having cited Article 23(2), Lord Justice Warby says the checklist is cast in mandatory terms and calls for specific provisions, and then counsel for the Secretaries of State said that these specific provisions can be found in general principles of human rights or administrative law or in existing articles of the GDPR, and that is rejected as unconvincing. And there's a reference to the text of Article 23(2) itself, which is a point I've already made. And then paragraph 49, the conclusion, the last two lines of that page, is that a derogation has to be effected by a legislative measure that's tailored to the derogation, legally enforceable, and contains provisions that are specific to the listed topic, to the extent they're relevant to the derogation, precise and producing a reasonably foreseeable outcome. And then between letters B and C, Lord Justice Warby concludes that the Court of Justice has repeatedly rejected submissions to the effect that domestic legislation should be held to pass muster on the basis that sufficient safeguards could be found elsewhere in the overall legal framework. And then the essence of the reasoning is summarised at paragraph 50. Broad legal provisions are insufficient to protect the individual against the risk of unlawful abrogation of fundamental rights. And then Y is explained between D and E. The need is for the legislature to take time to direct its attention to the specific impacts which the derogation would have, to consider, and that's the legislature to consider, whether any tailored provisions are required, and if so, lay them down with provision. And that will, of course, have benefits which are set out in E for transparency, the quality of decision-making, and review of proportionality. So that's the principal basis for the existence of the requirement being summarised by the Court of Appeal. We say entirely correctly there. The Court then cites the EDPB guidelines at paragraph 51, which are supportive of the Court's conclusions. And then finally, at paragraphs 53 and 54, the Court deals with the nature of a legislative measure. And at the bottom of page 445, the Court says, even assuming without deciding it's permissible for some of the specific provisions to be contained in some separate legislative measure, there is no such measure. not been suggested the draft internal guidance qualifies. Then there's a reference to the ICO's guidance. And then it said its provisions might be a relevant consideration for a public law decision maker, as counsel for the Secretary of the State submits, but I'm not at all persuaded that would be enough to comply with Article 23.2. Applies to a range of private bodies and individuals. And then this, in any event, the term legislative measure, whatever its precise scope, must refer to something other than a non-binding code promulgated by a regulator that counts as a relevant consideration for the purposes of administrative decision-making. And we say applying those principles to the immigration exemption policy document, it doesn't pass muster. And those comments in paragraph 53 are amply supported, we say, by the Court of Justice's case law as well. So that was the statement by this court of the task for the judge and the principles which the judge was expected to apply. And we say the judge applied those principles entirely properly.
In our case, the judge appears to have taken the view that it would be sufficient to remedy the problem he identified to have a statutory code.
Yes.
But is it your submission that that would be enough?
Yes.
The words you've just quoted to us suggest that that would not be enough.
Well, the difference between a statutory code and what we have here is the statutory code is itself approved by Parliament. And so a code of practice, the code itself has to be subjected to the affirmative resolution procedure. And that is the difference between a proper code of practice, if I can call it that, and the immigration exemption policy document. And that is because a proper code of practice meets the mischief which the Court of Appeal identifies at paragraph 50 of its judgment, namely that the legislature should, alongside the measure containing the derogation, consider at the same time what safeguards against abuse ought to be present.
But how does that sit with the text of paragraph 3 of Article 23, which says it must be in the regulations?
Because a code of practice is made by regulations.
Ah.
And so just taking the standard UK practice of how codes of practice are provided for. So, for example, in the Police and Criminal Evidence Act and in the Investigatory Powers Act, which are probably the two most well-known examples, the provision which has been made is that a code of practice has to be subjected to public consultation and then made by regulations under the affirmative resolution procedure. So that's what I mean by a code of practice proper. And I think that's what the judge understood by a code of practice proper. We conceded and accepted below that a code of practice of that kind would satisfy the requirement of regulations because it was made by regulations.
Forgive me for interrupting you,
No,
but the only reason I'm pressing you a little further on this is that, for example, the PACE codes of practice are not, in a sense, binding because, for example, there can be breaches of them which will not sound in any legal remedy. But you accept that that would be sufficient?
I accept that because they have been approved by a legislative process, that would be sufficient. And there is an argument, and there is, to be frank, a more extreme argument to be made by reference to some of the Court of Justice case law, that a code of practice, even if it has been approved by, for example, an affirmative resolution procedure following consultation, would not qualify at all. But we do not go quite that far.
Thank you.
But we say the judge was right, and indeed we conceded that a code of practice of that kind would be acceptable because it's been approved by a legislative procedure and contained in regulations. That type of code of practice is, as my lord puts to me, not strictly binding in every case, but nonetheless it can only be departed from as a matter of well understood principle for good reason. And there'll need to be a justification for a departure from it. And the justification, of course, has to be particularly cogent because of the procedure that goes into the approval of the code of practice. It's because the code of practice has been approved alongside the derogation and has been approved by Parliament that it has to be taken particularly seriously. Doesn't mean it's absolutely binding in every case. Can I just, before I move on to the grounds of appeal, and perhaps just to give a slightly more complete answer to some of my Lord Justice Singh's questions, show the court two of the Court of Justice decisions. First of all, the EU-Canada passenger name case, which is opinion 115, and secondly, what's said about legislative measures in Telly 2 and Watson. The EU-Canada case, opinion 115, is Authorities Volume 1 at tab 18. This is a case where the Court of Justice was reviewing the compatibility with EU law of a proposed treaty between the EU and Canada for the transfer of passenger information. This scheme is relevant to this case because the proposed treaty contained something quite similar to the immigration exemption, which was found to be inadequate. The relevant equivalent to the immigration exemption can be seen on page 721.
731?
Sorry, my lord, 721.
21.
In Article 12 of the draft treaty, and the heading is Access for Individuals. The basic right, and it was a right of subject access, is in 1. Canada shall ensure that any individual may access their passenger data. And then the exemption is in 3, which is that disclosure may be subject to reasonable legal requirements and limitations, including limitations necessary to deal with criminal offences, public and national security, with due regard for the legitimate interests of the individual concerned. The court then set out the principles that it was applying from paragraph 139 of the judgment, the opinion. That's page 745. And the language that we see in paragraphs 139, 140, 141 is very familiar because it's the same language or similar language as is seen in the other cases that were quoted by the Court of Appeal in the first judicial review. And in particular, in paragraph 141, at the start of 141, we see the principle that the legislation which entails the interference must lay down the clear and precise rules governing the scope and application and imposing minimum safeguards. So it's the legislation containing the limitation on the right has to itself set out the safeguards. And then that is applied to numerous different features of the draft treaty, including the disclosure provisions in Article 12. And the disclosure provisions are dealt with in paragraphs 216 and 217 of the judgment. That's on page 757. And there were lots of other points that the Court of Justice didn't like about this agreement, but it also rejected the adequacy of the subject access provisions for the reasons it gave. The derogation from those important rights was not sufficiently well particularised or covered by appropriate safeguards. finally, on the case law as to what amounts to a legislative measure, the most detailed analysis of that we've been able to find is in the Advocate General's opinion in the Telly 2 and Watson case.
Do we need to worry about that? We're told in our case it's a regulation.
No, probably not. Maybe I'll just give the reference to it in case any members of the court want to see what was said. That's in Authorities tab 12, and it's paragraphs 150 to 152, where the Advocate General looks at the different language versions of the concept of legislative measure.
Just give me those paragraphs again.
Authorities 1, tab 12.
Yeah.
Paragraphs 150 to 152.
Yeah.
And the conclusion is that the principles to be applied are slightly different to the in accordance with the law analysis under the Strasbourg case law. And one sees that that's what the court does in practice. I'm told I've just, by Mr. Knight helpfully, it should be tab 17, not tab 12.
Yeah, I was going to say.
So, having looked at that, and before dealing with each of the grounds of appeal in turn, could I ask the court to look again, and hopefully for the last time, at the revised version of the immigration exemption? So that's in the supplemental bundle at page 84. The duty under 1A, capital A, is to have an immigration exemption policy document in place. And then under 1B, there is such a policy document in place, so long as it explains the Secretary of State's policies and processes for determining the extent to which applying the UK GDPR will be likely to prejudice immigration control and so on. And then B, particularly importantly, policies and processes for where it's determined that any of those provisions don't apply, preventing, and then 1, the abuse of that personal data, and 2, any access to or transfer of it otherwise in accordance with the UK GDPR. So what the regulations say is that if you want to see the policies and processes for preventing abuse of personal data or the transfer of it outside the UK, otherwise in accordance with the UK GDPR, then have a look at the Secretary of State's policy document. And that is where the fundamental problem for the Secretary of State, we say, arises. Because the Secretary of State accepts that the policy document is neither regulations nor a legislative measure, and the Secretary of State have been very careful not to rely on the content of the policy document, whilst at the same time telling us that that is where we look to find the safeguards against abuse or transfer in breach of the UK GDPR. And that's, we say, the paradox of the Secretary of State's case. At the same time that these provisions satisfy, for example, 23(2)(d), specific provisions in regulations dealing with abuse, whilst at the same time not actually providing for those specific provisions about abuse in regulations and allowing the Secretary of State to determine them under an entirely different and non-legislative procedure. And we say, in light of what must be the proper interpretation of the words regulations, this can't be satisfactory, because the whole purpose, as we've seen from the Court of Justice's case law, is to require a legislative process in relation to the safeguards that are considered at the same time as the derogation itself, for the reasons this court gave in paragraph 50. This is a mechanism for avoiding the consequences which this court identified in paragraph 50. That's our basic case. And if one then looks through the policy document itself, and I'm not going to take the court through it, one does not find any additional or new safeguards, save for one. The only thing it includes as an express additional safeguard is that necessity and proportionality have to be considered in each case. And that's what the judge said needed to be in regulations rather than in the policy document. Beyond that, and we'll be corrected if we're wrong, it doesn't contain any additional safeguards that weren't already in place. So turning to the grounds of appeal, ground one is a challenge to the judge's conclusion that the requirement of necessity and proportionality needed to be in regulations. We say that the judge's finding was no more than an accurate application of the judgment of this court in the first judicial review, in particular applying paragraph 54. So the immigration exemption is engaged where the exercise of a right would be likely to prejudice effective immigration control. The immigration exemption says that the exemption has to be applied case by case. That's quite right. But what it doesn't say is that even if there is prejudice, one must then conduct a proportionality analysis.
I don't know if you're going to come to this, but what is a case? You were giving us an example of bulk processing. If the Home Office decides they want to look at everybody who's arrived at Heathrow for the last 6 months, is that a case or is that 7 million cases, or however many people arrive at Heathrow in 6 months?
Presumably it must be when the Home Office comes to consider whether it is going to comply with its general obligations, for example, under Articles 13 and 14, because many of the rights that can be derogated from don't require me to write a letter to the Home Office saying, "Dear Home Office, please tell me if." There are rights which are triggered by the start of the processing. So case by case presumably must mean when the processing commences and decisions are made for it to continue.
Not necessarily individual by individual.
No. I think properly construed it must be in something wider. And there is no express statement on the face of the regulations that a necessity and proportionality analysis has to be conducted at that point. And of course that may be significant because there may be, for example, a case where there is modest prejudice to the interests of immigration control, which might be quite a theoretical form of prejudice, and that might need to be weighed against the very significant use of data in respect of a large number of people, most of whom the Home Office has no concerns at all about their behaviour. And in those circumstances, the use of the data may, I don't say it will be, but may not be proportionate. Depends on the circumstances. But that exercise at the very least needs to be carried out, and we say there needs to be a requirement for it to be carried out on the face of the legislative measure.
Is another way of putting your submission, Mr. Jeffy, that the phrase "to the extent it's likely to prejudice" is only part of a proportionality exercise, because it's looking at one side of the scales, whereas if you were to do a true balancing exercise, you'd have to look at the other side of the scale. Is that how you're putting it?
Yes, that's right. a proportionality exercise in full requires not just identifying the prejudice to immigration control, but also the extent of the prejudice to the rights, and then balancing the two. And the degree of respect, for example, that a court will give when that balancing act is challenged will depend on the circumstances, but it still has to be carried out. And there's nothing on the face of this derogation that requires that full balancing exercise to be done.
Well, the argument against you is it's inherent in to the extent that, as interpreted, for instance, in Lin.
And we say that the difficulty with Lin is that that's not an issue which was considered by the court. What the court did in Lin is the court decided on the facts of that case whether where the proportionality balance ought to lie. What the court didn't consider in Lin wasn't an argument that was put to it, was that on the face of the exemption in that case, it was necessary to write in a proportionality balance. That's a separate issue. And I would add, because it seems that the Secretary of State is about to give you a long list of other exemptions, one has to be extremely careful before accepting any submission from the Secretary of State that the sky is about to fall and every other exemption ought to be treated in the same way. And the reason for that is that the legal basis for the immigration exemption is very different from the legal basis of many of the other exemptions. So, for example, Lin concerns the old crime exemption in the old Data Protection Directive. That is not a derogation in EU law terms, and that is because crime and policing have never been within the scope of EU law. The so-called crime exemption, or the crime derogation, is not in fact a derogation in EU law terms at all. It merely reflects the proper scope of EU law. EU law never covered that type of processing, except in the areas of justice and home affairs which require unanimity. So the UK, when it was a member of the European Union, signed up to some of that, including the Law Enforcement Directive, but not other parts. And so we don't accept that each exemption has to be treated in the same way, or that it would necessarily lead to the same result. Much of this is about whether or not it is EU fundamental rights that are being derogated from, as opposed to an area where EU law has never applied.
Mr. Jeffrey, can I ask you for your help with this? It may not be an issue between the parties, but speaking only for myself, I am not entirely convinced that Mr. Justice Green was right to say that the phrase "to the extent likely to prejudice" in fact encapsulates the classic proportionality test. Because as we know, there's lots of jurisprudence on what proportionality requires, and actually what it requires in EU law can be different from what it requires in ECHR law. And one of the things that it might be said it requires is a balance to be performed. But I mean, I may be doing an injustice to Mr. Justice Green. I'm not sure I see in his interpretation of that phrase actually a reference to the need to do a balancing exercise. Am I wrong?
No, the point my Lord is putting to me is entirely fair. I think probably the simplest way of analysing Mr. Justice Green's judgment is that it is a purposive reading of the relevant rule, which allowed him to conduct the proportionality balance in a very anxious situation involving a capital case. If one were to take a slightly more black letter approach to the actual text of the words he was considering, it's very far from obvious that full proportionality balance is included in that. And indeed, that's what enabled the Metropolitan Police, with a very straight face, to make the submission to Mr. Justice Green that no, they did not have to carry out a proportionality balance because that's not what the exception required. And that was rejected in firm terms, but it was a perfectly proper submission to make on the text of that exemption. And indeed, that's been, one sees that type of analysis, the type of analysis which my Lord Justice Singh is putting to me in some of the other cases. So moving away from EU law for a moment and going back to the European Convention on Human Rights, one well-known case about in accordance with the law is Gillen, which is a case about stop and search and suspicionless stop and search. So a senior police officer was able to make an authorization covering a particular geographical area, which enabled officers in that area to stop and search anybody for particular purposes without having any suspicion that they'd done anything wrong. And that power could be exercised whenever, and the legislation said it was expedient to do so. And one of the reasons which the European Court of Human Rights gave for concluding that those arrangements breached the Convention was because the term expedient did not include on its face a necessity and proportionality balance. And expedient, something may well be expedient without it being proportionate. And the UK's argument was the argument that the UK always runs. It's, well, Gillen happened after the Human Rights Act came into force, so any police officer exercising public powers obviously has to comply with the Human Rights Act and obviously has to act in a proportionate way when exercising his or her powers, so it's all fine. And that argument was rejected by the Strasbourg Court. We haven't included it in the bundle, but I'm happy to get it for the court if that's of use. It's not directly relevant to this case, which is an EU law case, and I say the case law is stronger. But one sees that type of analysis across the piece in the analysis of fundamental rights, that where there are interferences taking place that are quite significant, it is often necessary to write in, on the face of the legislative scheme, requirements of proportionality. And that's what happens in practice, usually. This case is something of an outlier at the reluctance of the Secretary of State to do that. One sees express requirements as to proportionality as a standard drafting technique whenever these type of interferences take place. So they are across the Investigatory Powers Act, that every exercise of intrusive powers under the Investigatory Powers Act, and my Lord Justice Singh will be familiar with this, contain basic limitations in Section 2 requiring necessity and proportionality analysis in every case. And that's a feature that the courts have placed particular reliance on in the analysis of the lawfulness of those provisions. Going back, those provisions also exist in the Telecommunications Act about national security notices and all sorts of other provisions. Where there is a serious interference, where there is a proportionality requirement, the appropriate approach is to require it on the face of the legislative measure containing the derogation. That's what we say about ground one. We say that the judge was, in essence, right for the reasons he gave. On ground two, which is about the immigration exemption policy document, I've already substantially developed our submissions, but in outline, we say Article 23 2D deals with safeguards against the risk of abuse. We say that the safeguards have to be incorporated within the regulation itself. And that is so because it ensures that the legislator considers safeguards against abuse alongside the intrusive derogation itself and tailors the safeguards at the same time. And it also means that the safeguards have the same legal effect as the derogation. The vice of this arrangement is that the text of the revised immigration exemption says on its face that the point of the policy document is to set out policies and procedures for preventing abuse and abusive transfers abroad. And so the way in which the legislator is trying to comply with 23(2)(d) is by the policy document. But also conceding entirely correctly that the policy document is not itself either regulations or, if they want to go wider, a legislative measure.
Well, I mean, your point, I think, is that Article 22 2D requires the regulations, we now know, provision made in the exercise of the power, to contain specific provisions as to safeguards, and it's not good enough to say, well, we'll have some.
Well, the Secretary of
We
State will have some.
not going to tell you what they are now, but we will have some.
Yes, they're not specific. It doesn't meet the requirement of specificity, which is expressed. And we would also say it doesn't amount to regulations, because if you pass regulations saying that the Secretary of State will have some measures in a policy, then that we say that clearly, given the history of this provision, that can't count either. It's neither specific nor does it amount to regulations. And there may be all sorts of arguments around the edges, in particular around what constitutes a code of practice, where I've already made submissions. But whatever it may mean, we say it doesn't mean this. And the reason we say that there is a rule of law problem, to use the judge below's language, is that there's a real risk that the safeguards get ignored.
Sorry, getting
A real risk that the safeguards against abuse are ignored, or they are given less priority. And, perhaps most importantly, it is impossible for the legislator, that is, ultimately both houses of Parliament acting under the affirmative procedure, to properly analyse the proportionality of the derogation itself, because they need to see what the safeguards are which accompany the derogation that they're being asked to sign off on. That's why it has to be in the same legislative measure. I'm sorry, Mark.
No, forgive me for interrupting you. Strictly speaking, the legislator is the Secretary of State, but you do make the important point that it's subject to the affirmative resolution procedure, and so there is parliamentary scrutiny. And I was wondering, Mr. Jaffe, whether part of the sort of underlying philosophy of this thinking is a bit like what Lord Hoffman said about the principle of legality in Sims, that it's about requiring Parliament to face up squarely to what it's doing. In other words, you're being asked by the executive to endorse a statutory instrument which says this is the derogation. So you know the extent of the derogation when you're sitting in each House of Parliament, but you're asked to prove the extent of the derogation without knowing what is going to be on the other side of the balance. Is that
My Lord,
part of the thinking?
My Lord, that is part of the thinking. I probably don't need to go quite as far as to call it a principle of legality issue.
No, I understand.
There are very strong echoes of that.
Yes.
It can perhaps be put more lightly as the legislator's job of considering the proportionality of the measure, which, and the legislator's judgment as to the proportionality of the derogation is given considerable respect. But it's very difficult to do that proportionality analysis if you've got no idea what the safeguards are going to be.
Yeah, well, that's one point. And I think another point which the judge made below is that once you've signed it off, because you've given it the affirmative resolution, you don't know what the Secretary of State, in other words the executive, is going to do in 12 months' time.
Right.
And they don't have to, is that right? You don't have to come back,
No,
put
not
your
at all.
policy document in front of Parliament and say, well, now that we've changed the balance, and we'd like you to endorse this, because by then you've already signed off on the regulations.
Right.
Have I got it right?
That's quite right. And that's why I say there is a contrast with what I've called a code of practice proper, because the code of practice is itself made by regulations and therefore has to go through the affirmative procedure. And if the code of practice is to be amended, so for example, if on reflection some of the safeguards are too onerous and they shouldn't be continued with, it would be necessary for the Secretary of State to go back to Parliament and seek a change, seek affirmation or approval for a change to the code of practice. So it enables those basic legislative safeguards to exist. And we say that's significant and what lies behind the obvious purpose of Article 23. Ground 3, I'm going to leave mostly, if I may, to my learned friend Mr. Knight. But can I just mention one or two points about it which are more relevant to the respondent's case? The basic issue on ground 3 is that the judge concluded that subparagraph G had not been complied with because there hadn't been any proper consideration of the risks to the rights and freedoms of data subjects when making the derogation, the immigration exemption. And what G requires is specific provision, where appropriate, dealing with those issues. The Secretary of State, in their submissions, profess quite a lot of uncertainty as to what G means or what G requires. We say there isn't in fact any great mystery. It's formulated quite clearly in the EDPB guidance, which the court was shown earlier today. And what the point of G is to do is to require some of the things that I've been discussing with the members of the court this afternoon, which is consideration alongside the derogation of what the risks are to data protection of the proposed measure and the type of safeguards that ought to be put in place. And then for those risks to either be identified or addressed. And that's what the EDPB explanatory guidance states. And again, there is quite a lot of precedent for that type of drafting technique that one sees in modern legislation concerning data rights. Again, the most recent example is the Investigatory Powers Act. Section 2, right at the start, contains a requirement for necessity and proportionality everywhere. And then Section 3 sets out a series of general safeguards for privacy, identifying the particular risks to privacy that Parliament had identified that would occur as a result of the legislation and how they were to be addressed. So it identifies categories such as journalists and their sources, the protection of legal professional privilege, and various other types of special cases where special consideration would need to be given. And that is what G is really all about. That is the type of provision that's envisaged. And again, the courts in this country and also elsewhere have given great weight to those provisions because they show Parliament expressly thinking about what the risks are alongside the intrusive powers that are being granted. And there wasn't any attempt to do that here. That's the judge's basic point. What the outcome of that consideration would be is ultimately a matter for the Secretary of State with the approval of Parliament. But the judge's concern was it just didn't happen.
Mr. Jeffrey, I'm aware that there was a decision of this court over the summer, I think, about the compatibility of the IPA. Is that going any higher, do you know?
My clients, my different clients, have made an application for permission to appeal to the Supreme Court on a relatively small number of grounds, which is being considered. But the current position, I think it's fair to summarise, is that the divisional court, which included my Lord Justice Singh, judgment has been broadly approved, save on one issue, which is being remitted by this court.
Thank you.
That's our response to the three primary points which are put forward by the Secretary of State. That leaves the procedural fairness point and also the respondent's notice points, which I hope I can take relatively briefly if that's convenient. I've already said that for what it's worth, it's probably not going to make, the procedural fairness issue is probably not going to make too much difference. But I think it's probably worth briefly explaining why we say the judge acted entirely properly on the evidence which he had before him. The context to the judge's decision about time, and the judge gave 3 months, is that in the first judicial review, the Secretaries of State offered up to this court what this court thought was a pretty leisurely timetable. Right up until the end of council submissions, when it was conceded that a much more tight timetable was perfectly possible. The opposite is happening today. what's happened today is we all thought that the Secretary of State certainly would be able to do it in 3 months, but we're now told it will take longer. Now, all of those events that happened in the past are recorded in this court's remedies judgment. I probably don't need to go through it, but just so the court has the references. It's tab 13 of the authorities, paragraphs 41 to 46. And the court's basic conclusion was that the Secretary of State's approach was, and I quote, far too relaxed, and everything could have been done a great deal faster if a greater sense of urgency had been followed. And the Secretaries of State were given 3 months from the date the Court of Appeal handed down its judgment. What happened here, just so the court has the chronology, is the hearing below was on the 21st of March of this year. With considerable efficiency, the judge produced a draft judgment on the 28th of March and asked for corrections the following day so that the judgment could be handed down. There was then an exchange of brief submissions by email in which my clients suggested that 2 months was an appropriate period, and pointing out that an opportunity had been given to put in evidence already, and the Secretary of State objecting to that, and the judge giving reasons. That exchange of correspondence and also the reasons given by the judge, I'm afraid haven't made it into the bundle.
Well, I was going to ask you about that. I was going to say that as far as I know, we haven't got any reasons.
And the judge did give reasons, so could I just hand those up? I've also got copies for my learned friends as well. So it's in reverse chronological order because it's an email chain. But first of all, at the end of the email chain, there's an email from my learned friend, Mr. Erdley, saying it hasn't been, this is at the bottom of page 3, hasn't been possible to agree an order. Please see our draft order and supporting submissions. And what those submissions said is, broadly speaking, can we have a month to make submissions about how long we'll need? So not this is how long we'll need, but we need some time to make submissions about how long we need. The response from Mr. Grubeck, my junior, is on pages 2 and 3.
Yes.
And paragraph 3, it's pointed out, in, if I can summarise it, they're doing the same thing as they did last time. And then also in paragraph 3, pointing out the Information Commissioner in his summary grounds said, you've got to put in evidence about this. We can't have the same as happened last time, again, my summary. Paragraph 4, this is the second time you've done it. Please reject the timetable, and we suggest 2 months. Then Mr. Knight for the Information Commissioner responds, and he says on instructions that reluctantly the Information Commissioner would be willing to accept the Secretary of State's timetable. And then the judge's ruling is on page 1, which also contains the judge's reasons. If I could invite the court to read that.
Speaking for myself only, Mr. One concern I have is that it was sending out a draft judgment and saying you're going to hand it down the following day is a very tight timetable. In any case, could it be said that in this case, given what had happened, for example, at the remedies stage of JR1 in this court, was there any particular urgency that judgment had to hand it down the following day as opposed to the following week, for example?
I don't think there was any particular urgency in handing it down at any particular time. However, this is a case in which it had been pointed out by the Information Commissioner, and actually we subsequently put in submission saying we agreed, that if there is going to be evidence on how long it's going to take, which is updating evidence, it needs to be before the court at the substantive hearing. And that was a point that was made in these submissions, and the judge has taken those into account in reaching his decision. And the judge has accepted the submissions that were made perfectly properly, that the task for the government is not particularly difficult, that the task is relatively limited, as is set out in the draft judgment, and the judge increased the amount of time that the claimants proposed from 2 months to 3 months, which is the same amount of time as this court gave. So the judge has just taken a broad view, which is you had the opportunity to put in evidence, you were told you needed to put in evidence by the other parties, you didn't put in evidence, it can't be longer than the amount of time you had before the Court of Appeal, the second time round, that's my decision. I may be summarising it rather too briefly, but we say that's an entirely proper and reasoned decision, which is, in the circumstances and given the history of this case, an entirely legitimate one. In answer to my Lord's point, if this had come out of a clear blue sky, if there hadn't been the first judicial review and an extensive exchange of evidence, including a day of litigation in this court about relief and the timetable for relief, then I would have to accept the position would be entirely different. But on a second time around, particularly in circumstances where the basis of the judge's decision was A, modest, and B, wouldn't have come as any great surprise, we say a 3-month period is perfectly legitimate. The final points are the respondent's notice points. And we say the judge was also, or should have made the declaration which he did for some additional reasons. The first additional reason is under subparagraph A, which is about the specificity of the immigration exemption. And we say that effective immigration control is too broad a concept as to satisfy Article 23(2). Our submission is really quite a simple one, which is that the concept of effective immigration control has clearly been drafted so as to be as broad as possible. It's the opposite of a targeted derogation to deal with a specific problem. And the reason why I opened and explained some of the use cases that the Secretary of State has put forward is that the respondents have consistently been quite confused by what the true necessary use case is for the immigration exemption. In reality, given that most of the rights themselves have exemptions or exceptions built in, we suspect that the most important use case for the immigration exemption must be various forms of bulk analysis and processing. We don't know that because of the immigration exemption. But that's what we suspect is really the justification which is lying behind that. And there is at least some support for that from the Samidi's witness statement. Now, if that is what really lies behind the immigration exemption, then it doesn't need to be as broad and comprehensive as the current drafting suggests. If what there is there needs to be a targeted exemption to allow certain types of large-scale processing for particular purposes to take place to be justified, then there ought to be a targeted exemption for that purpose, which is justified for its own reasons and also supported by safeguards that are tailored for it. We also say that there is no reason to go as broad as possible in the legislation. And that's because the primary legislation, the Data Protection Act, already contains a Henry VIII clause, section 16, allowing exemptions to be added to, modified or deleted. So if an exemption needs to be made broader, as experience develops, then a broader exemption can be made. It's not a once and for all process. And we say compare that with opinion 115, where the exemption to subject access required was a general objective of combating terrorism, and a general carve-out was made for various understandable public purposes in the draft treaty. And what the Court of Justice said is, no, that's too broad. So we say that the judge should also have made a finding that the degree of specificity in A was inadequate. The two other points which we make are first of all about C and E. We were concerned that the effect of the exemption as amended is that the actual processing would not need to be carried out by the Secretary of State. We've been told in my learned friend Skeleton and also in his submissions today that that is not the case. And in those circumstances, I'm not going to pursue that point. And then finally, we say that specific provision needed to be made about time limits for the holding and retention of data. The judge's conclusion, which is supported by the Secretaries of State, is that provision for time limits was automatically built in because of the nature of the exemption itself. What the judge said is it's a prejudice-based exemption, so the time limit for which the exemption can apply and the period related to that for holding data will be for so long as the prejudice continues. We say that that is insufficient, and the reason that's insufficient is because where you have time limits for retention and review, that enables a reconsideration of whether or not it's still necessary to withhold the disclosure of information and apply the exemption. So it's perfectly correct to say that the exemption may not need to continue to be applied for many years. It might be that the sensitivity is only for a period of days, weeks or months. But provision for time limits to allow the review of what data is being held and why gives practical effect to that fact, that data may cease to be sensitive over time so that changes can be made over time. And we say that was overlooked and not considered by the judge, and provision ought to have been made for it, perhaps, for example, in a code of practice, which would be the traditional place for it. My lords, my lady, I think that's probably it. May I turn my back for a moment? Unless I can assist the court further, those are.
Thank you, Mr. Jaffe. Mr. Knight, do you want 10 minutes this afternoon, or would you rather start tomorrow?
Might be preferable to start tomorrow, my lord, and I will do my best overnight to pare things down.
Right.
Where I can.
We will finish presumably by short adjournment tomorrow.
I would have thought so. I would have thought with some cutting I'll be an hour or less.
Right. All right. Well, in that case, we will rise now and sit again at 10:30 tomorrow.